Okay, this will be a Mark Hisslingberry jury charge. Here we go. Ladies and gentlemen, as you go in to deliberate, I want to tell you once more, you are to decide the defendant's guilt or innocence on the evidence and on it alone. The evidence in this case consists of the verbal testimony of witnesses and the exhibits which have been marked and received in evidence. The exhibits are just as much a part of the evidence as are all the spoken words of the witnesses, but you are to ignore answers of witnesses that were stricken out, all those which the court ordered stricken, or matters which were not allowed into evidence. The only factor which may properly influence your review is the duly admitted evidence before you. In the course of the trial, from time to time, questions arose on matters of law. You should not concern yourselves with any of the rulings which were made by the court on any questions of law. These rulings are not part of the evidence in the case and must not be considered by you, nor are you to consider any colloquy which the court may have had with counsel. Such colloquy or any statement made by the court or counsel is not part of the evidence, and so you must not consider it in your deliberations. And you should not draw from any rulings or statements or mannerisms of the court or from any questions asked by the court the inference that the court has an opinion as to the guilt or innocence of the accused. The court has no such opinion. That is purely your duty as the members of the jury. Also, under no circumstances must the jury deem any statement by me, the court, or any words of mine toward either counsel or any tone of my voice or expression of my manner as a personal reflection on counsel. The final issue in this trial must be decided by you, the jury, regardless of what counsel or the trial court may think or say on the subject. An important factor to bear in mind at all times is that the quality of the testimony is controlling, not the amount of the testimony or the number of witnesses speaking from one side or the other. I will now cover the law specifically applying to the crimes which I am submitting for your review. I know that I shall continue to have your whole attention to what I am about to say. The indictment charges that the defendant in Orleans Parish and on or about March 24, 1995, willfully, feloniously, and with malice did shoot and kill Mary Beth Walker with a gun. Homicide is the killing of one human being by the act or the omission of another. Here the people contend, and it is stated on the charge, that the deceased, Mary Beth Walker, was killed through the act of this defendant. Now, there are different degrees of homicide, namely murder in the first degree or second degree, and manslaughter in the first degree or second degree. In this case, we are concerned only with the crimes of murder in the first degree as a felony murder, murder in the second degree, and manslaughter in the first degree. We are not concerned here with manslaughter in the second degree. There are also different types of homicide with which this case is not concerned. I see no point in elaborating on these, since, if I should do so, it may only confuse and prolong this charge. The killing of a human being is murder in the first degree when done with a certain and pre-planned design to effect the death of the person killed or of another. And this is generally referred to as direct and premeditated murder. The killing of a human being is also murder in the first degree when done without a plan to cause the death of a person by a person engaged in the commission of or in trying to commit a felony upon or affecting the person killed or some other person. And such a killing is referred to as a felony murder, or murder in the first degree as a felony murder. In other words, in order to find the defendant guilty of felony murder in the first degree, it is not needed that the people prove that the defendant thought and planned on a way to kill Mary Beth Walker in order for you to find him guilty of a murder in the first degree as a felony murder. In order to find the defendant guilty of murder in the first degree as a felony murder, you must find that the defendant killed the deceased while engaged in the doing of a felony, in this case robbery. But bear in mind that if you find the defendant did have a design or intent to kill the deceased, that fact does not prevent you from finding the defendant guilty of felony murder. If you should find that the people have shown his guilt of that crime, murder in the second degree is the killing of a human being when done with a plan. That is, an intent to cause the death of the person killed or of another, but without deliberation or planning. Thus, in murder in the second degree, just as in felony murder, intent and planning form no element of the crime. But in murder in the second degree, it is necessary to prove both the killing and the design to kill, that is, an intent to kill. Manslaughter in the first degree, which, as I said, I will also submit to you for your consideration, is the killing of a human being when committed without a design to effect the death, that is, without an intent to kill and in the heat of passion by means of a dangerous weapon. Gentlemen of the jury, I know this has been a long and tedious trial, but we are finally at a stage where your duty comes into play. You already know this, but to recap a bit, the trademark company withheld from some employees and failed to withhold from some of its employees wages and salaries paid to its workers during the time involved federal income taxes and Social Security taxes of $120,000. The business failed to pay to the government the sum withheld as it was required to do under the law, and it then became bankrupt and had no funds from which the government could collect the withheld taxes. To assure the withholding taxes are paid to the government when the employer fails to pay them, the Congress has enacted a special rule in the law, namely that any person working with a corporation who have the duty in the operation of the business to see that the taxes were paid to the U.S. government and who did fail to do so is personally liable in the form of a penalty for the sum of the taxes not paid to the government. The penalty, which is named by law, is usually referred to as the 100% penalty, since the amount of the penalty is equal to the sum of the taxes which were not paid. Thus, the penalty is merely a means of getting the taxes not paid over, and it enables the government to be made whole. The employer in this case was a corporation, and as stated earlier, it can act just through its agents, directors, and employees. Every corporation which is an employer must have some person who has the duty or job of withholding and paying over those taxes which the law asks it to withhold and to pay over to the government. There may be more than one responsible person, but there is always at least one. Thus, there may be more than one person liable for the 100% penalty. The government says in this case that the plaintiff was one of the persons liable to collect, to account for, and pay over the taxes which were supposed to be withheld. The government also contends that the failure of the plaintiff to pay over those taxes was willful. With regard to these issues, though, you are instructed that the plaintiff has the burden of proving to you, by a preponderance of the evidence, either that he was not a person whose duty it was to collect and pay over the taxes here named, or else that he did not fail to collect and pay over such taxes. The first issue for you to decide then is if the plaintiff was a responsible person. The term responsible person includes a person who is connected with the corporation employer in such a manner that he has the power to see that the taxes are paid, or the power to make final decisions concerning the corporation, or who determines which creditors are to be paid and when they are to be paid. The term responsible person may be corporate officers, employees, members of the board of directors, or stockholders. The meaning of the terms is quite broad and is not limited to the person who should prepare the payroll, checks, or the tax returns. A responsible person need not even be authorized to draw checks for the corporation so long as he has the power to decide who will get such checks. In other words, the responsible person is any person who can effectively control the finances or determine which bills should or should not be paid.